So I hope the questions relating to legal personality of animals and the broad question of rights of animals have been discussed to an extent that you can do further studies on that topic. The introductory part I hope is covered reasonably. So for us to talk in terms of animal rights, we can definitely take help from utilitarian principle to justify reducing suffering, although that in itself is not sufficient to talk in terms of rights of animals. Okay, and for that we have to look beyond just utilitarianism as a principle. But the thing is that any right that we talk about uh, has to be based on, and is based on, as I personally understand, is based on some utilitarian calculation, is based on broadly on the principle of consequentialism, that it's the consequences that make certain action justifiable and certain others not justifiable. But that in itself is a long discussion, and the debate goes on. So I would just leave it there. But if one is not satisfied with it, then one can also apply that Kantian categorical imperative as a principle to even in the case of animals. And then when the question of rationality arises, then one can then use scientific examples to show that, well, some animals show the same kind of rationality as humans do. But that also leads us to the problem that many others don't. And how do we talk in terms of their right? So anyway, the debate will go on. So I don't want to spend any more time on this. You can do research on that topic as well. So anyway, today we are going to move beyond that topic and look at certain other relevant topics related to law of personality, law of persons. So when we talk about law of persons, okay, we are to differentiate between these two different expressions. Okay, there is something known as double capacity, and there is something known as double personality. Okay, now double personality, I would say this for your clarity's sake, is that double personality does not exist. Okay, double personality does not exist. However, you may come across situations, okay, cases where it seems that law recognizes double personality. So, for example, once a company is incorporated, there is separate legal personality, so it becomes a separate legal entity. Once it becomes, after incorporation, a separate legal entity, then the people who founded it, the people who created it, are not the same as the incorporated legal entity. Okay, so in such situation, it gives us the impression that there are two different personalities. But then the personality here, the two different personality are different. In fact, the incorporated entity has a separate legal personality, and the individuals who created it, or someone who holds share in the company, their identity is separate. Now the company can also enter into a contract with one of the shareholders because their legal identity is different. So that does not in any way mean that same person has two different personalities. Okay, so I would tell you this, that double personality, okay, does not exist. Although when it comes to corporate aggregate, it seems to be the case, especially in companies, okay, it seems to be the case that there could be double personality, but in fact they are separate personalities. Now, as opposed to that, there is another expression, okay, term known as double capacity. Now, double capacity does exist, and we don't have to be confused about this terminology. Okay, so for example, in our university, if registrar's office, if registrar's position is a position of legal personality, because the registrar has the capacity to sue and be sued. Okay, if you look at our statute, so the position of registrar of our university has a that position is a legal personality. Okay. Now the thing is that position is chaired by a human person. Okay. So could we say that that human person has two different personalities? Well, as I said, double personality does not exist. Okay. So it's not the case. So that human individual, okay, is a natural person in her own individual capacity. However, she, she is a natural person, so that's her, one capacity in which she functions, and that's innate in her because she is a human being. Whereas she also chairs the position of registrar. Okay, she officiates in that capacity. Okay. Now, that does not mean that she as an individual has a separate legal personality. No, she has a different capacity. The personality is separate. The registrar's legal personality is separate. Now, that personality, okay, because at the end of the day, some human has to, function, okay? So the registrar as an individual functions in that capacity. That does not mean that same individual has two different personalities, but one can be functioning in different capacities, okay? So there are different capacities in which one person, okay, who has only one personality, okay, that is maybe because we are talking about humans, so natural personality, okay, so natural person. They might be functioning in other capacities, okay, but that does not mean that they have different personality. So one may have a power to act in an official or representative capacity, but one might not have the same power in their own individual capacity. So one person can be functioning in two different capacities, but that does not mean that they have two different personality. Okay, so double capacity is not to be understood as double personality. Okay, so if we say that double personality exists, that means what? Law will allow me to enter into a contract with myself. That's something that law does not allow. Okay, I cannot enter into a contract with myself. Okay, that's because I'm one person. I'm not two different persons. So any time, any situation when one person functions in two different capacities, okay, two different capacities, because it's not a case of double personality, because had it been double personality, law has to allow, legal transactions. So because it's a case of legal double capacity, law does not allow you in your one capacity to enter into legal relationship with yourself in a different capacity. That's a restriction that the law imposes. So this is something that you need to keep in mind. Okay, so would be that if you had double personality, then you would enter into legal transactions with yourself. That's not allowed. So it's not a case of double personality. It's merely a case of double capacity. So I hope this concept is clear. Is it clear?
Yes, sir.
Okay. So, okay. But later on you will see, okay, so for example, some cases, landmark cases like Salomon versus Salomon Company Limited and Lee versus Lee's Air Farming Limited, some of these cases where the courts have held that once the incorporation happens, okay, the individuals who founded the company and the company itself are two different personalities, okay? So there are two different persons, okay? So, however, those are not cases of one individual having two different personalities. Those are really cases of two different personalities. So in such case, they can now enter into contract with, so the incorporated company can definitely enter into a contract with the one who founded it, okay? So that's there, but even that will not be the case of double personality as is claimed in many different, places. So that would be really a case of separate legal personality. So yes, so that means that we need to talk about persons, legal persons now, or juristic persons now, okay? So far we discussed examples of, cases of natural person, okay, and also certain cases where natural persons, where basically problematic cases of natural persons, And we also dealt with whether animals, because they are also natural beings, okay, so why should they not be considered as persons, natural persons? Legally, that's possible, no denying that, but why not as natural persons? From now onwards, we are going to look at the cases of legal person in that restricted sense, that is, juristic persons, okay? So, non-living beings as persons. So yes, those are the cases of legal persons. So entities that are persons because they are recognized by the law as persons and not otherwise. So they are not natural person. Okay. So Salmon says a legal person is a subject matter other than human being to which the law attributes personality, and thus law personifies a real thing. So here you see that obviously when that book was written, the idea of animals having personality was not even being considered. Hence, this kind of understanding that only humans could be natural persons and nothing else. Okay, so he says that a legal person is a subject matter other than human being to which the law attributes personality. So we'll assume that any non-human entity, okay, non-living entity here, okay, would be considered as legal person to which the law attributes personality. So unless the law attributes personality, it is not a person, it is not a legal person. So it's a very positivistic approach, as you see here. Is it a legal person? The answer to that question depends on whether law has attributed it personality. Okay, so law could personify a real thing. It could personify anything. There is no constraint on that. There could be certain, practical limits, but, in terms of our imagination, in terms of our possibilities, no limit really is there. Okay. So there is, there is no, therefore, so whether, why law should personify something, okay, is there a theoretical necessity? Well, not really, okay. It is merely a question of efficiency. It is merely a case of practicableness, okay. It simplifies our thoughts and speech, okay. So, for example, think about a corporation, okay. A corporation is incorporated and it becomes a separate legal entity. Now, for example, think about a firm, okay. A firm consists of certain number of, partners, okay. Now, they are limited numbers, okay, and they may enter into legal transaction with someone else. So, it is a number that is still manageable. But the number can increase. It could be 200, 300, 400,000, okay. Now, imagine managing a legal relationship between 1,000 on the one side and thousands on the other. You will need supercomputers, but even that might not be possible, okay. So, in such situation, okay, it is better that transactions between these two groups of people are done in a certain way, okay. So in an efficient way, okay. So for that, sometimes law can personify this group of persons. So there is no or there could be other reasons as well. Okay, I'm just giving you one such example. Okay. So think about an object. An object cannot enter into legal relationship with humans, okay, but it could be personified, okay. An idol, think about an idol. An idol will not go to the court to sue someone, okay, or be held accountable. So in such case, okay, when it is efficient for us, okay, to personify it, okay. So that's why it is to be understood that, okay, this idea of legal personality is not something that is of theoretical necessity, okay. It's not based on some meta theory, but simply a question of efficiency. It simplifies our understanding, okay, simplifies our thought and speech. It simplifies the legal dealings that happen, okay. So when it comes to legal persons, there are two elements that you need to keep in mind, okay. So there is a thing that is personified, and then that thing is then attributed an intention, okay. An intention is attributed. So be it a will or be it an interest, okay, whatever you talk about, for this thing to have claims of rights, etc., you have to attribute an intention there, okay. So the thing personified here is considered as the corpus. Corpus means the body, okay, the corpus of the legal person, okay, and the corpus that is, and this body which is considered as the corpus of the legal person, it is in that body that animus of fictitious personality is attributed. Okay, what could be the corpus, though we will discuss. So you have two different elements here. Okay, there is a thing personified, and that is the corpus, okay, of the legal person. That is the body of the legal person, and it is in that body that law infuses animus, that is the intention of a fictitious personality. Now here's something that you need to listen to very carefully, okay, and keep that in mind. Okay, so when we use so in our lay use, okay, in our day-to-day, in our lay use, okay, we personify many things. Okay, we personify many things. So we use words in such a way as if we are referring to that something as person. Okay, something, some entity, some group of individuals as persons. Okay, we do that. We quite often do that. So for example, when you use the word my parents, okay, you are using the word parents as if the word represents something whole, okay, and as if that is a separate person in the legal sense. Well, not really. Okay, so there are many other ways in which we personify things. Okay, now that is to be distinguished from the idea of legal personality. Okay, the idea of legal personality is different from the idea of mere personification. Okay, so here how it goes, that all legal personality involves personification. Okay, all legal personality, so everything that constitutes legal personality involves personification. However, not all personified things are legal personality. Okay, so in our lay use we personify things. Okay, I refer to my beautiful plant. Okay, I talk to it, I refer to it as you, whatever. Humans can do crazy things. Okay, well, one may even personify one's belongings, a car, and things like that. Okay, that's there. Okay, so we personify things. Okay, however, merely because we refer to things as if they are persons does not mean that they are legal personality. Okay, and it's not just these cases, these examples where that I just gave you, in which it is clearly understandable that yes, it's not a case of legal personality, but there are other confusing cases as well. Okay, so the idea is that all legal personality involves personification. Not all personified things are legal personality. Okay, so for example, if a deceased dies, okay, and until the property is devolved, okay, meanwhile the estate of the deceased, okay, what is it? Does it have a separate legal personality? Well, in earlier times, okay, maybe some jurisdictions, okay, they might be recognized as a separate legal person, but here that's not the case. Okay, even though we refer to the estate of the deceased as if it's a separate it's a legal person, so in our lay use, we use the word as if it's a case of person, but that's not really the case. So for it to be a legal personality, it has to be legally recognized as a person. Okay, so estate of the deceased used not in the strict sense of legal personality, but is just personified. Okay, similarly, think of a partnership firm. Okay, now in some legal system, partnership firms are also given separate identity, but generally the idea is that firms, okay, firms are not considered as legal persons. They're just individuals. Okay, and they have joint and several liability, as we discussed, if you remember, in obligations. Okay, so that's the case. We personify. Okay, so what is a firm? It's really the partners together. It's really the partners together, but they are liable jointly and severally. Okay, so there is no separate entity. The firm is not a separate entity, separate from the partners who constitute it. So even though we use the word firm as if we have personified it, but it's not a case of legal personality unless there is a legal system that recognizes it as a separate legal personality. Similarly, bench of judges, not really we personify, but not really a legal personality. Okay, and you can come up with any other example. Unless how do we, basically find out whether it's a case of legal personality or not? You have to look at the law. What does the law say? Okay, and that will tell you. So legal personality, okay, involves law's recognition of something as being a person. Okay, so legal personality is not reached until the law recognizes over and above the associated individuals a single entity which in a manner represents them but is not identical with them. Okay, so whenever legal personality is recognized, okay, now the persons, okay, associated individuals are separate, and the entity which is considered as legal, as legal person is a single entity that represents this individual but is not identical with those individuals. Its existence is now separate from these associated individuals who might have created it. So companies basically that we are going to discuss. Okay, so you have corporations, any incorporated bodies. Okay. Once incorporation happens, the incorporated body has a separate legal existence. It's a separate legal entity, and the individuals who officiate are separate people. Okay, or individuals who founded it are separate people. Okay, so the corporations, okay, which could be a group or a series of persons, okay, and thereby a legal fiction, are regarded and treated as itself a corporate, person. So corporations are separate person. Okay, they could be, these positions could be officiated by either individual or a series of individuals. Okay, that will determine what kind of corporation it is. We will come to that in a while. Okay, so you have many such examples. Okay, you have corporations. Okay, so you have companies, incorporated companies. Okay, then corporations could be other corporations as well. Okay, you have municipal corporation. You could have other incorporated bodies, as long as it is, as the name itself says, it is incorporated. So the body is recognized. So something that is not really in existence, by virtue of incorporation, okay, you recognize it as a separate legal entity. So yes, corporations, whatever the form. Okay, registered trade unions are also considered as having separate legal entity. And societies, okay, if societies are created under Societies Registration Act, so can create separate legal personality. Now these legal persons, okay, basically the corporations can be categorized into two different categories. Okay, so before that, okay, before we talk about the corporation, let's deal with this question of what is incorporated. So when we talk about incorporation of a thing, okay, what is it that is incorporated? Okay, so you can, based on what is incorporated, you can have three different kinds of corporations, three different categories of corporations. Okay, so what are those? So in one case, you can the entity that is incorporated, okay, the corpus here are basically individuals. Okay, it could be individual humans. Okay, so those which are constituted by personification of group or series of individuals. So if what is incorporated are individuals, whether they are groups or series of individuals, okay, that would be one kind of corporation. So here the corpus is really the individuals. Okay, they form the corpus of the legal person which is created here. Okay, and they will be considered as the members of the corporation. But once the incorporation happens, the incorporated entities separate. Okay, then it is not necessary that what is incorporated are individuals. Okay, it could be an institution as well. Okay, it could be an institution, so there is no individual there. It could be, for example, a hospital, if there is a statute in which the university is incorporated. Well, fine. Okay, and in such case it could make a particular official, a particular chair, okay, to represent the university. The registrar could be the usually is the person who represents the university. That's there, but here what is really incorporated is not an individual, okay, but an institution, okay, whatever it is, okay. So in such case, the personality is attributed not to the individuals but to the institution itself. So who is the legal person? Well, it is the institution, okay. And there is a third category where the corpus is neither individual nor institution but a fund, okay. So even a fund could be a legal person if it is recognized, so in a particular legal system. So charitable funds could be, recognized as having separate legal personality. So it could have rights. Obviously, it will not, function on its own. It will be represented by someone. So that's there. Even trust estate could be recognized as separate legal, person. And then, as I said, estate of a dead human, okay, or someone who's bankrupt. But that depends on how the legal system really treats the estate, okay. So it's possible that even funds are recognized as a legal person, okay. In such case, it is really, the corpus would be the fund, okay. Now, corporations can be broadly categorized into two different kinds. And what are those? One is the corporate aggregate, the other one is corporate soul. Okay. Now, what is a corporate aggregate? So remember where individuals are incorporated. Okay, the first kind that we discussed earlier. Okay, different classes of legal persons. Okay, the first is where individuals are incorporated. Okay, so we said that it could be either a group of person or series of person. Well, if it is a group of person who are incorporated, that would be case of corporate aggregate. Okay. So incorporated group, there is an incorporated group of coexisting persons, okay. So you have many such examples. There could be registered company, it could be municipal corporation, whatever. So if it is a group of persons who are incorporated, then in such case, it is known as corporate aggregate, okay. Although what is incorporated has a separate legal existence, And similarly, there is something called corporate soul, okay, where it is not a group of persons but a series of successive persons, okay. So imagine President of India. Now here you do not have multiple individuals officiating that particular post, okay. So you have one president, then that president is replaced by someone else, okay, or the Queen of England, okay, sovereign basically, okay, who are considered as corporate soul. So whenever we have corporate soul, you do not have many representing that particular corporate body, but it's one individual who represents, series of individuals who represent the corporate soul. Now the idea is that persons may come, persons may go, but the corporation goes on. That's something that we are going to discuss in a while. So I hope this distinction is clear. Is it clear?
Yes, sir.
Okay, the others?
Yes, sir. Yes, sir.
Okay. I see only 2 students responding. What about the rest?
Yes, sir.
Okay. Okay. So that's the 2 different kinds of corporation. Okay. Now the question, next important pertinent question that arises is as to why incorporate? Why incorporate? So incorporation, as I told you earlier, okay, has some benefit. Definitely one of the general purpose, reason for which it is done is the question of efficiency. Okay, it helps us. There are certain advantages of incorporation. Okay, now we will look at the specific advantages of incorporation. Okay, so when the incorporation is complete under whatever law that exists, okay, for example, when it comes to incorporation of companies, you have the Companies Act 2013, okay. So whatever it is the law under which an incorporation happens, okay, maybe it is through enactment of a statute, okay, statutory incorporation also happens, for example, in case of our university. So, here the legal personality is created, okay. So whenever incorporation happens, okay, we create a separate legal entity. Okay, we create a separate legal entity. That separate legal entity, not real individuals, okay, because the individuals are separate now. What is incorporated has a separate legal existence, okay. So that separate legal entity or separate legal person, okay, being that has so many advantages, okay. What are those? The first important one is that it has independent corporate existence, okay. It has independent corporate existence. What does it mean? What is incorporated has a separate existence, from those who created the corporate body here, okay. So the idea is that the property of the company, so if a company is incorporated, okay, think of a company, okay, if the company is incorporated, the property of the company belongs to the company, okay, and not in its members, okay. The property of the company belongs in the company, in the name of the company, and not the members who might have created the company. The company now may sue and be sued in its own name, okay, not in the name of its members. So members do not become liable here, okay. It is the company which can sue and be sued, okay. So that's the separation, okay. Those who created, they might have created, okay, there might have been promoters, the company might have directors, whatever, okay, but the company has a separate legal existence, okay. So one may sue the company, or one may be sued by the company in the name of the company. So it has a separate existence, okay, and that existence is separate from the members, okay. So there might be shareholders who hold share in the company, but the existence of the shareholders is separate, okay, and their liability will be limited to the extent that they hold their shares, okay. We'll discuss that as well. So that means there is a separate independent corporate existence, and it also means, okay, it can enter into contracts with third parties independently, okay. It is not the members, okay, it has separate existence, okay. So it can independently enter into contract, okay, and that means that it can enter into contract with even the members of the company. So even if you hold some share in the company, okay, even then the company can enter into a contract with yourself, okay. So that's why I told you that seems to be a case of double personality, but not really, because the personality of individual is separate, member is separate from the personality of the company itself, because that's a separate legal entity, okay. So yes, it can now enter into contracts, okay, even with the members. So that's there. These are some of the advantages. So these provisions can be found. For example, you will find, so these are pretty general. You will find these similarities in almost all the countries wherever companies are incorporated. But in India, you have Companies Act 2013, and Section 9 refers to some of these advantages that I just mentioned. So it says, from the date of incorporation mentioned in the certificate of incorporation, such subscribers to the memorandum and all other persons as may from time to time become members of the company shall be a body corporate, okay, by the name contained in the memorandum, capable of exercising all functions of an incorporated company under this act and having perpetual succession and a common sale with power to acquire, hold, dispose of property, both movable, immovable, tangible, intangible, to contract and to sue and be sued by the said name. So once incorporation happens, all these powers, functions are in the company, okay, separate from the members who might have created. So yes, that's the advantage, okay. Now, for in order for us to understand, okay, how this separate legal entity idea really works, okay, separate legal personality idea really works, we have to refer to one very important case by the name Salomon and Salomon and Company, okay, or Solomon Company. So I don't know which one is the correct way of referring. So you'll find it both the names used in different places, okay. So the name, I'll just type it here, just a second. So this is a famous case you will easily find. Okay, so this is a case where this idea of separate legal existence, separate legal entity, or this doctrine of separate legal personality was clearly laid down. Okay, it was understood before as well, but this case clarifies it. Okay, so in this particular case, I will not go into the details, but simply what had happened in this case. Okay, so Salomon is an individual who owned a boot making business. Okay, he owned it as an individual, and subsequently he created a company by the name Salomon Limited. Okay, and most of the shares were held by himself. Okay, and the members of his family, and there were also debentures, so basically secured debts, which were also owned by him. Okay. So once the company is created, Salomon transfers that shoemaking business to this company that he had created. Okay, and most of it was paid through this purchasing of shares and debentures, secured debts, but there were also unsecured debtors. Okay, creditors. Now what happens is that afterwards the business goes bust. Okay. Now the company goes into liquidation. Now what happens is that when it comes to paying the debtors, okay, we all know that secured debtors have priority over unsecured debtors. Okay. Now who were the secured debtors? It was Salomon himself. Okay. And the unsecured debtors were other people. Okay. Now the matter goes to the court. Okay, first it goes to appellate court, and ultimately it goes to I think the highest appellate court in England, that would be House of Lords. Okay, where it was decided that after the incorporation, the company becomes a separate legal personality. Okay, so these people who took the matter to the court, who were aggrieved because they were insecure creditors, and the company was bankrupt, so their money could not be paid. Okay, and Salomon's own interest had a priority because those were secured debts over that of these other people whose debts were not secured. Okay, so they thought that the company is a sham, which has been created so as to defraud us or deny us of these benefits. Okay, what is owed to them. Okay, so they claim that the company is a sham company. However, when the matter reached the highest appellate court, it decided that once the incorporation happens, the company has a separate legal personality, it's a separate legal entity, it has separate legal existence. Okay, so obviously here Salomon cannot be made liable individually. Okay, why? Because the company has separate legal existence. Okay, so that's broadly what had happened in this particular case. Okay, so Salomon will not be liable individually for the debt, but the company is bankrupt, and when liquidation happens, some creditors are prioritized over that of others. So the secured creditors are prioritized over the non-secured creditors. Who is the secured creditor? Salomon himself. Okay, so obviously he has priority. So it seems so unjust, but because they recognize this idea of separate legal personality, that's the conclusion that the court arrived at. A similar case also happened in New Zealand, which was ultimately determined by the Privy Council. Okay, and that goes by the name Lee versus Lee's ear farming company. It's more or less the same. Okay, a company was created by someone by the name Lee. Most of his probably, I don't remember exactly, it had 3,000 shares, I think, and 2,999 were owed by Lee himself, and Lee himself was an employee of the company. Okay, he used to top dress crops using aeroplane, and I think some mishap had happened and he died, and he sought compensation under certain law. Okay, now that was denied. Okay, because it was contended that Lee himself was the company, but when the matter ultimately reached the Privy Council held that, well, Lee's widow essentially will be entitled to the compensation now, is entitled to the compensation because the company has a separate legal personality. So that's the idea of separate legal personality. So once incorporation happens, this company has a separate legal personality. The property of the company belongs to the company, not to the members. It can be sued and can sue in its own name, okay, and can enter into contract with third parties, even with the members, as you see in the Lee and Lee's air plumbing company limited case. So all these are some of the things that happen, can be considered as advantages of incorporation. Okay, so the same has also been held in India in certain cases. So in Messrs Electronics Corporation Limited, Corporation of India Limited versus Secretary Revenue Department. In this particular case, the Supreme Court of India, among others, observed that a clear distinction must be drawn between a company and its shareholders, even though that shareholder may be only one, okay? Even though there is only one shareholder, a distinction has to be drawn. That is the central or a state government, okay? So it could be that the central or state government is the shareholder, okay? Even in that situation, we have to hold that there is a separation here. Okay, so in the eyes of the law, a company registered under the Companies Act is a distinct legal entity other than the legal entity or entities that hold its shares. So that's there. So separate legal personality is considered as one of the advantages. It could also be considered as a disadvantage if you look at it from the other side, okay, from the other side. Well, we will look at that once we discuss the advantages, okay. Now, what time is it? Okay, I have some time. Then another important advantage is that of limited liability, okay. When it comes to limited liability companies, okay, if the company is a limited liability company, okay, then the advantage is that the liability is limited to the extent that you hold, for example, shares in that company, okay. So if you hold shares worth whatever the amount, 10,000, whatever, your liability extends only to the extent that you hold the share. And your individual assets will not be liable. Okay, so even if you hold a share worth something, it is only what you hold there, okay, in terms of share, which is liable, not your personal, property, not your other properties, okay. So when the company is, when there is a case of limited liability, if the company is a limited liable company, okay, so when the company is wound up, the members shall be liable to contribute to the assets of the company in accordance with whatever the act says, okay. So in limited companies, what is the limit here, okay? What is the limit that is imposed? That would be that no member is bound to contribute anything more than the nominal value of the share held by him. So your personal property is separate. What is held liable? The share value that you hold, okay, and the liability only extends to that, okay, and nothing outside of that. So that's the idea of limited liability. But that applies only in the case of companies which are limited liability companies. Okay, you will know that from the word company limited. Okay, you will know that there could be unlimited companies as well. But this advantage is in case of limited companies. Another important advantage would be that of perpetual succession. Okay, so the company's property belongs with the company. Okay, so members may come and go. Okay, the company shall retain its existence. Okay, it shall retain its all legal advantages that come with it. So there could be certain rights, certain obligations, powers, immunities, property, whatever it is, okay, remain with the company. So as long as the company itself does not come to an end by virtue of the law of the land, or as it is applicable, or whenever it is wound up under the law, okay, until then there is perpetual succession, okay. So members may come and go, the company remains, okay. So notwithstanding any change in its members, okay, members may come and go, the company shall retain as the same entity with the same privileges, immunities, estate and possessions. The death or insolvency of an individual member does not affect the independent existence of the corporation. So individual may be insolvent, individual may die, but that will not affect the separate existence of the corporation, and hence they will have this idea, what we just called as perpetual succession. Now, perpetual does not mean till eternity. Obviously, it can be ended as the under the law. So a company can be wound up. Okay. So when the company is wound up under the law, okay, for example, under the Companies Act, okay, then obviously its life comes to an end. Okay. But other than that, members may come and go. The corporation succeeds, the company succeeds perpetually. So in a case by the name Gopalpur Tea Company Limited versus Panhoek Tea Company Limited, just so that I can... in this particular case, what said that though the whole undertaking of a company was taken over under an act, okay, which purported to extinguish all rights of action against the company, neither the company was thereby extinguished nor anybody's claims against it. So an example of how this perpetual succession really works, okay, so unless it is ended under the law, okay, it goes on. Then just like, quite related to this idea of perpetual succession is the idea of separate property, okay. So once the incorporation happens, the company's property belongs to the company, okay, and company's property is separate from the property of the members, okay. So incorporation helps in separating the property of the company from that of the properties of the members. Once incorporation happens, the company's property is company's property, members' property is their own property. So even though there are changes in the membership of the company, that will not affect the title of the company to the property, because company's property is separate. So the company becomes the owner of the property, and all other assets as are there, belongs to the company and not in the members. Your liability only extends, as we discussed, to the amount of share that you hold. Okay. So in Bacha Guzdar versus CIT Bombay, okay, just a second. It has been said that it has been held that the company is a real person, okay, real person, not natural person. It's considered as existing, in reality, okay, in which all its property is vested. The property is basically vested in the company, and by which it is controlled, managed, and disposed of. No denying that, company in the absence of humans will not be able to manage it, okay, but they are there to help the company, okay. So basically, remember cases of minors, okay. Even in their cases, there could be guardians, okay. So humans could be in a similar way guardians of the company. So even then, okay, even if the same is managed by individuals, the company's property really belongs in the company, not in those who manage it, not in those who hold share, okay, in the company. And we also discussed that means that the company has a capacity to sue and be sued. So since it's a body corporate, it can be sued and it can also sue, okay. So that's definitely possible. So civil suit definitely possible. But the problem arises when it comes to criminal complaints, okay. So criminal complaints can be filed by the corporation, but as we know, it has to be represented by a natural person. But the thing is, what about criminal responsibility of corporations themselves? That's where the problem arises, okay. You can incarcerate a person, okay? Imprison a person. For that matter, in extreme cases, even death sentence is imposed, okay. Now, when we talk in terms of fines or damages, obviously civil suits do cover that aspect, okay. But crimes are not merely about compensation. It's about punishment. How do you punish a corporation? When a company commits, something that would constitute, crime, well, holding only individual members there may not be sufficient. Okay, we might need to hold the entire company, responsible. However, the problem is that when you hold the entire company responsible, many people who have invested, they are not at fault. Okay, so what do we do then? So there are lots of problems there with making companies criminally liable. So that's an area of research that one can, focus on. In fact, I know a person who's researching on this particular topic, but you'll come across many such. So many suggest that companies compulsory termination of the company would be equivalent to, for example, imposition of death sentence on individuals. But the problem is not really that easy. When you end the company, you do not just end the company, but many other innocent individuals, okay, livelihoods of many people who are probably employed by the company. So what other innovative ideas can we come up with? It's something that is worth researching into, something that if you guys are interested in, can definitely look into. But given the paucity of time, I will end this topic here. And definitely when it comes to civil suits, okay, that's easy, not that problematic as criminal complaints. So for example, defamation, okay, so a company can have a reputation, okay, so company has a right to fair reputation. It can affect the prospects of his business as well, okay. So since it affects the prospects of his business, it has a right to fair reputation. Hence, the company can sue against any remarks that are likely to damage the reputation of the company, okay. However, that same immunities would be there, okay, so as would be available in normal situation. So if someone defames the company and it is proved, then the company can seek damages, okay, if the same affects its business, okay. So these are certain advantages of incorporation. In the next class, we are going to discuss about the situation, the disadvantages. So you see, you probably already have seen that, it creates some unjust situation where the companies take, or individuals who incorporate the company take undue, unjust, benefit from the fact that companies have separate legal personality. So there are situations, okay, quite often those are statutorily laid down. So for example, Companies Act 2013 lays down the situation when individuals are held liable, okay, so that's there, not really problematic. Where do you find it? You find it in the written law itself. There are other situations where, mostly judicially laid down, where it is justifiable, or the courts have held that they will lift or pierce the corporate veil. So those are the situations that we are going to discuss in the next class. So that's it for today.